Hello viewers, this is Dr. Kashinath Neharkar and I welcome you in my YouTube channel at lecture series on income tax laws. Friends, in this lecture we are going to discuss the concept of residential status and the determination of residential status of individual. But before that, please subscribe this channel and press bell icon to receive notifications regarding further video lectures. So friends, let's start with today's concept of residential status, because this concept is very important in calculation, in levy and collection of tax. Friends, you know what is concept of income tax. So income tax is nothing but the tax which is imposed on one's income that is received in a particular period, that is called as a previous year. So it is a tax on income. So the government have enacted the Income Tax Act 1961. It provided the mechanism, process, authorities for the purpose of levy and calculation of tax. And as the Constitution itself provides that there shall be valid law, there shall be valid procedure for levy and calculation of tax, collection of tax. Therefore, the Income Tax Act 1961 provides residential of status as one of the essential to be considered in determination of taxation liability, tax liability of individual. So, residential status of individual or that person, whether it is natural, artificial, etc., his residential status will help us to decide his tax liability. It plays a very important role in calculation. So how we see, because the residential status and payment of tax, these are very closely connected with each other. As you know, the income tax is imposed on the basis of a residential status of person, though there are other things also that should be considered, like what is his income from various sources, then what are the different tax slabs, then what are the different tax rates. But we cannot directly decide what tax rate shall be applicable to that person or what will be the tax liability of that person without considering his residential status. Therefore, the income tax is imposed on the basis of residential status. The person who is resident is liable to pay tax on his all income, whether he has received income in India or from outside. His whole income will be considered for the taxation purpose. So this is the concept, this is the thing that must be considered when that person is called as a resident of India. And secondly, the person who is non-resident of India is liable to pay tax on income that is earned in India only. It means his income which he has received or earned outside the India is not considered for the taxation. So this is therefore the determination of residential status is very necessary. Now we must see how the residential status is determined. And see, the residential status is determined on the basis of stay of person in India. This is regarding individual residential status, and regarding other persons, its management, registration, control, etc. These are the things. On the basis of that things, the residential status will be decided. See, the citizenship of person is not necessary here. As we know, the residential status, nationality, etc., these are in other contexts, these are considered on the basis of citizenship, nationality, etc. But here the residential status is determined without seeing his nationality. It means the resident of India can be Indian citizen or that can be foreign citizen also. So what is important for determination of residential status? what is the stay of that person in India, what is the period of stay of that person in India, so that will be considered. So the residential status shall be decided as per section 6 of the Act. So let we see what are the provisions relating to residential status, determination of residential status under section 6. So firstly, before that we must see what are the kinds of residential status. So there are two kinds of residential status. One is a resident of India and second is non-resident of India. So first is resident and non-resident. So resident is divided into two categories, resident and non-resident. Then we must see who is called as a resident and when a person is called as a non-resident. See, firstly we are going to discuss who is called as a resident. So the person, again this concept, resident concept is divided into two categories. One is a resident and ordinary resident, and secondly a resident and not ordinary resident. So these are the kinds of residents for the purpose of income tax. Now we see how the residential status of individual will be decided as per section 6 of that Act. So we must see, as I have already told you, that the individual stay in India is considered for determination of his residential status and not his citizenship, etc. These are not the important things for determination of residential status. What is considered is his stay in India, for how many period he resides in India, he lives in India. So therefore on the basis of his stay, that person can be either resident or that person can be non-resident. So firstly we will see when a person is considered or decided as a resident, for that purpose that person, that individual must satisfy any of following these two conditions, any of following condition. If that person satisfy any of these two conditions, that person can be called as a resident of India. Either he must satisfy basic condition A, or if he do not satisfy basic condition A, then he shall satisfy B condition, basic condition B. If that individual satisfy any of these two, then that person will be decided as a resident. So we must see what is first condition. The first condition is that that person stay must be at least 182 days or more during previous year. It means that previous year for which the income tax liability is going to be decided. So that person should be in India for at least 182 days or more during that previous year. If that person satisfies this condition, then that person is declared as a resident. But if that person, that individual do not satisfy first condition, then we will apply second condition. And second condition is that if that person is in India for 60 or more days during that previous year, the previous year which is in a question, or the previous year for which we are going to decide the tax liability of that person, that is previous year, and apart from that year, if that person is in India for 365 days or more during 4 years immediately preceding the relevant previous year, then also that person is considered as a resident. So in the first condition, his stay in a particular relevant year will be considered, and in second condition, his stay in India for 5 years, particular previous year plus 4 years before the previous year, that will be decided. And if that person is in India for 60 days or more in that particular previous year, and before that previous year, if that person is 365 days or more during 4 years before the previous year, that person is also called as a resident of India. So this is very necessary. You must understand what is the difference between these two things. So second condition is applicable only when that person do not satisfy the first condition. So that person will be called as a resident of India. Then again, the resident of India is divided into two categories. This resident is also categorized in two categories, and these two categories are a resident and ordinary resident, and resident and non-ordinary resident. So when an individual is called as a resident and ordinary resident, that for that purpose this is decided by section 6 clause 6, because the first these two conditions, basic condition 1, basic condition 2, these are provided by section 6 clause 1, how a person or how individual is decided as a resident. But when any person is found a resident, then section 6 clause 6 provides whether that person is a resident and ordinary resident, or he is a resident and non-ordinary resident. So when that person is decided, when that person is declared as a resident and ordinary resident, see, when that individual satisfy section 6, it means when that person satisfy both conditions which are mentioned under section 6 clause 6, then that person will be considered as a resident and ordinary resident. So we must see which are those two conditions. First condition is he has been a resident in India at least 2 years out of 10 years immediately preceding the relevant year. So that person must be a resident of India for at least 2 years out of previous 10 years. Then this is the first condition, and he has been in India for a period of 730 days or more during 7 years immediately preceding the relevant year. So if resident of India, whether he is resident by fulfillment of basic condition A or B, if that resident of India fulfills two conditions under section 6 clause 6, then that person will be called as a resident and ordinary resident of India. And then who is resident and not ordinary resident of India? So the resident, the person who satisfy either basic condition A or basic condition B, and then he do not satisfy section 6 clause 6 both conditions, then that person will be called as a resident and not ordinary resident, because that person may fulfill one condition under section 6 clause 6, or that person may not satisfy any of these two conditions. So in such circumstances, that person will be called as a resident and non-ordinary resident. Now we must see when a person is called as a non-resident. It means when our individual, he do not satisfy any of basic conditions which are provided by section 6 clause 1, that is basic condition first, basic condition A and basic condition B, then that person will be called as a non-resident of India. So friends, if you have any doubt regarding this, please write in the comments. I will solve your problems. So thank you friends. I hope you understood what is the process mechanism through which the residential status of individual will be decided. Thank you friends.